Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Oxford University Press. It's one in their Handbook series of books that we've reviewed. This one is just falling off at the moment. This one is called the Oxford Handbook of Fiduciary Law. It's been edited by 3 people and obviously has a number of contributors. The 3 editors are Evan J. Criddle, Paul B. Miller and Robert H. Sitkoff. And as I say, the book is an OUP publication. It's a heavy book. We'll have a look at it in a minute. Elizabeth was the lead writer with this work, and we were attracted by the title Fiduciary Law, which is a relatively new concept of a substantive area of law. But we've given it a title for our review, A Law Unto Itself, a single source of guidance on fiduciary principles. That's what you're getting. Let's just have a look at the book first of all. It's a heavy book, as you probably gather when it fell over there. There's the front, the spine you can see there, and then the back. You can see there's inverted out again, black print on a black background. White print rather on a black background. There it is. Now the dust cover has some detail on the back of the 3 editors and some information about OUP. Then you have some basic information about the book on the front. Let me go to the back of the book though first, because the series of course is a very important series. You can see that the index is a standard Oxford University Press index, a very detailed one, and has a lot of information in it, which you will find. It runs to quite a large number of pages as well, as you can see. And then you've got at the back, you can see the actual content. It runs to nearly 1,000 pages, this book. You can see the copious footnotes that are listed throughout. There's obviously a lot of sub-headings. If we go to the front, there's the front page there. And then after that, you've got the blurb about OUP and a very nice dedication from each of the 3 editors, which I'll leave you to read. We don't review books that we don't think much of. We only review books which are good books and relevant for practitioners and academics, hence the fact that we're reviewing this one. And then you've got the content section, part 1 running through the doctrinal canon, part 2 conceptual synthesis of fiduciary law, part 3 fiduciary law across history and legal systems, part 4 the future of fiduciary law and theory. And that's the end after that, and total of 48 chapters. Each one has got the name of the contributor. Then there's a detail about the editors. And after that you've got the detail of all the contributors. A large number of people involved in this book. The publication thereof, you can see the very large number of people. I can't, alas, mention all of them at this stage, but at least you've got some idea of who they are and where they come from. There's an acknowledgement section there. Then you can see there's an introduction from the 3 editors setting out what this book has. 4 principal objectives which are set out. It offers an accessible synthesis of fiduciary law, provides a single volume, a standard reference. It shows fiduciary law may be understood as a coherent field in itself. And fourthly, it supplies new historical, comparative and interdisciplinary perspectives, and it then explains the titles in the parts. And I'd like to just say that the actual handbook series is a major initiative in academic publishing, according to OUP, quite right too. Each volume offers an authoritative and state-of-the-art survey of current thinking and research in a particular subject area, and that's what we've got with this excellent book. I'm going to put it there and hope it doesn't fall down. There we are. Now, what do we say about the book then in a relatively short review? This. Over an extremely wide spectrum of law, almost endless in fact, you will encounter matters to which principles of fiduciary law must inevitably apply. The very word fiduciary, of course, refers to, if you'll pardon the expression, money. It's obvious then that fiduciary principles operate across both public and private law, from the highest levels of government and corporate activity to everyday business matters and personal relationships in which financial issues loom large. Hence the fact that this is probably an emerging area. It's, I think, quite established really in many areas, but probably new to quite a lot of people, and it's an interesting law for the future, if you like. And as is pointed out by the erudite editors in this, what is a stunning new handbook from OUP, fiduciary principles have become the subject of front-page news. High-stakes litigation and vigorous political debate. Indeed, such principles govern the workaday relationships that shape our daily lives. But should fiduciary law, which spans all legal disciplines, be regarded as a discipline in itself? The answer, as many might agree, should be a resounding yes. Hence the timely publication of the Oxford Handbook of Fiduciary Law. The idea for such a handbook apparently sprang from a conference at Harvard Law School in November 2017, at which the handbook's 53 contributors foregathered to discuss the theme of fiduciary law, charting the field. Tribute, of course, here must be paid to Professor Tamara Frankel, who introduced the notion, quote, that fiduciary law should be understood as a cohesive field of study, one of the principles, of course, governing the aim behind the book. The handbook then arrives at an opportune moment, say the editors, for the study and practice of fiduciary law, having as its purpose the provision of a single source to which readers can turn for guidance on fiduciary principles across a host of substantive fields, jurisdictions and epochs. It's further stressed, of course, that in its breadth and depth of coverage produced by a community of scholars, the handbook stands alone as a uniquely authoritative guide to the current state of the law and the scholarship in this field. Charting fiduciary law as a field, however, does require an understanding of why the law designates certain relationships as fiduciary, whether fact-based, that means by standards, or status-based, that means by rules. Now, the handbook's 48 articles, each one a chapter, of course, after the introduction, cover an amazingly broad range of topics. I was quite surprised, actually, by how wide the subject area was. Coverage, for instance, includes such areas as principles and duties, including the duty of loyalty and the duty of care. See, very much care being very much part of the negligence area, of course. Part 3 of the handbook, we found, examines fiduciary law across history, and it's comparative because it's across legal systems, including the English common law, canon law, Roman law, classical Islamic law, classical Jewish law, and Chinese, Indian and Japanese law, and a lot more. And there's much to contemplate here because, of course, just about every system is very much absolutely based upon the concept of money. And of particular interest, we thought, to practitioners on either side of the Atlantic is the handbook's part 4, the final part, in which the focus shifts to the future of fiduciary law and theory, including the economics of fiduciary law, its philosophy, its social and moral norms, and ultimately new frontiers in both private and public fiduciary law. Clearly, the transatlantic orientation of this handbook effectively broadens its scope, and there can be scarcely be a lawyer or legal scholar anywhere, we think, who wouldn't benefit by acquiring it. And I certainly think it's a huge amount of information, as I say, a lot of footnoting, a lot of detail, and I'm sure it would be of very great interest to many people in this area of their business world. Now, the date of publication of the hardback edition is cited as at the 27th of May 2019. Let's just have one last look at the book again. I moved it around because the light tends to be a bit shining on it a bit. There's the front, there's the spine, and then there's the back. If I just open it in the middle, you can see what I mean about the detail. Huge amount of detail, a lot of case law, which is actually set out nicely. The only thing I did have probably a bit of a concern about is that there is actually no proper index for some of the case law that's actually cited. It's not actually at the front or at the back, but as I say, what you do get right at the back is a very substantial index. So you can see again from the index that you've got a huge amount of information, and you should be able to find what you're looking for pretty quickly. Anyway, I'd like to thank OUP very much indeed for this new title in the handbook series. Makes our lives a lot easier, both as researchers, practitioners and so forth, and basically adds to the sum of human knowledge. Thank you very much to everybody concerned. Bye-bye.